for the faculty and the students. So today we have started, we have the new session on a workshop on the copyright. It is substantive and the procedural aspects. Basically, the copyright is the part of IPR, intellectual property rights. They are the two types of rights, tangible and intangibles. So tangible means the property which can be seen and touched, just like a movable and immovable. But intangible properties are those which cannot be seen and touched, but which has been created by the minds. For example, trademark, copyright, designs, patents, etc. So today we will have the talk on this copyrights. So with us, we have the learned speakers, Advocate Rupesh Kumar Sinha ji. He has completed his graduation in law from the BHU in 2008, and from 2008 to till 2021, he has been in a bar as a advocate from district level to High Court, including Supreme Court of India, where he has dealt the different matters such as DRT matter, that is debt recovery tribunals, national company law tribunal matters, then national company law appellate tribunals, and apart from this, the matter relating to the consumer redressal commissions. So now I give mic to the our learned speaker, Advocate Rupesh Kumar Sinha ji.
May I?
Yes, sir. Yes, sir.
Good afternoon, everybody. As my learned friend has already talked about myself. So before starting this session, I would like to make one of the submissions, which is regarding the workshop. I am not here to give some of the lengthy lectures on the, the procedural parts or as well as the law, what are the laws. But besides this, what I am trying to say is the experience which I has gained in all these things. How do we need to look into the law as a whole? It is the basic question. So before starting the Copyright Act, we need to understand that all the things which comes under or which is created by some sort of intellect is copyright. I mean, it is the IPR matters. So broadly speaking, if we categorize the IPR, then we have the trademarks, we have the patent rights, we have the copyrights, we have the design acts, and we have the geographical indications. All of you are aware about all these aspects. Likewise, the trademarks, which relates or which deals with the word mark or logo or the combination of word mark and as well as logo, which is used, either it can be used or it is proposed to be used. When we file the application for any of the trademark acts, I am just giving some sort of brief knowledge, brief information about it. So when we file some applications in respect of the trademark, then it can be filed as a user basis or the proposed to be used basis. Why all these rights are there? There are some motives behind it. The first thing is that if someone creates something, then there can be two things. The first thing is that he or she can keep it with himself or herself, or the second one is he or she can use it for his or her own benefits. That is called the economic significance. And the second one is to make anything aware or the public aware about the new invention or new concept or new ideologies, which is called as to bring something in the public domain. Now the question is, why do we need to bring something in public domain? Because it is not only that who creates something should have all the rights, that is the beneficiary rights, but at least the next generation or someone should get some inspiration or some ideas to bring something new. Likewise, if I say something in a patent case, I'm just giving you some of the examples. Likewise, we have certain sorts of, I mean, in the early 50s or 60s, you might have heard about all the things that is called diapers. So initially what happened that the diaper, some technologies were used in the diaper. The initial technology was used, which was in the year 1956 or 57, something around that years, which the idea is to bring, that is the newborn baby, to protect the navel of that baby. So one, it has started with the protection of that. The basic idea is to protect the navel. So a form is come with the patent is come with a U cut um, um, just to I mean stop the rashes. Thereafter, some other technology developed, just keeping in mind that, oh, that this technology is already in the public domain. So thereafter, some other things also comes into the picture. Likewise, the weight determination test is there. I am talking about especially in the terms of diapers. So these technologies, so unless and until the main concept of the IPR is not only to get something or to keep something with oneself itself, rather than to get the benefits of those rights, and thereafter to make them all those things, to bring that in those things in the knowledge of the public, general public, so that some other persons can come into the picture and some new technologies is developed, or it should be developed. It is also for the development or the betterment of the complete society as a whole. This is the basic concept of the IPRs, or the other fields are also there. So IPRs is the basic things. Now I come to the trademarks, copyrights and patents. Some basic things are, I mean, and designs. Some basic things are there which are correlated with one another. If something is protected under trademark, there may be the chances that the same thing can be protected under the Design Act or under the Copyright Act. Similarly, something which is, though the Patent Act is something very different, and it is especially used in the case of something which is especially confined to the invention of anything. Invention of anything as well as anything which is produced or which is created. The basic aim should be there that it can be used. It can be used either in present form or in the future form, but it can be used. The thing is that. So the same is with the patent, the things, the new ideology, the new concept which comes into the picture. Not only this, no other person has known, I mean, none obviousness is there. Meaning thereby that particular invention is not known to the person earlier. And the third thing is that that invention is capable of being used for the industrial purposes. Now, what happened when we talk about the copyrights? Copyrights, something which is not, I want to say that if something is not patentable, then it falls under the category of either the copyrights, because all these acts are interlinked with each other. Likewise, if I say the computer program per se, computer program is not a patentable thing. It can be protected under the Copyright Acts. Similarly, likewise, the what we can say is that design something which can be registered as a design, as well as the same thing can also be applied in the case of Copyright Act. So basically, all the things are related to the originality. Though the name vary from one form to the other form. Likewise, if we go into the trademarks, we generally say if something comes before us, in terms of the, I mean to say that in terms of any objections, if we file the application in a trademark cases, or if any objection comes relating to the absolute ground as well. Just give a few minutes, please. छोड़ दो ना, कल ले जाना. I am really sorry. So where was I? Okay, trademark. So if we talk, the things are there and there are the similar things. Likewise, if we say that if I am talking about the, in case if the some objections is raised, is being raised for the, on the grounds of some absolute grounds or the other grounds, in case of the trademark, then we generally say that the idea or the name or the trade name or anything else which we use or which we are intending to use is originally conceived by me. So the concept is originally, the similar concept is also there in the case of copyright, where we need to see that whether there is any originality in it or not. Even if we take the case of the adaptations, even adaptation, in the form of adaptation, there must be some substantial, some changes there should be there. I mean, some reforms should be there. To consider anything, whether there is any originality or not, there are certain parameters for it. The parameters which are related to the skills, labors. It is not as it is that if I am compiling something. Likewise, if we compile something, it should not be like a clerical job that we are compiling something and putting it on the desk of anything else. Whether we have put any extra efforts in compiling this is or not. This is the prime question. Likewise, I do not know whether you all have any idea about the Panchang, I mean calendar or not. So the Panchang calendar is something different from the normal calendars, because in the normal calendars we usually put the dates. So dates are there, all as well as the vacations time is mentioned there. But in the Panchang calendars, there are certain different aspects, whether which are related only to the Hindu mythology as well as the Hindu religions. So there is something there. So some skills, some efforts, some additional efforts, not only there is something, general saying is that do some smart work rather than do some general work or labor work. So all the IPers, we need to do something which is of something different. Some skills should be there, something which we need to create, or something which are put in the picture. There, something original should be there. Now the question is originality. So whether anything is original or not, there can be the chances that we get some ideas. Definitely we get the ideas how to write something, how to give the lectures, or even how to make something. We get the ideas from where? As earlier stated, that something which needs to be bring in the public domain for the benefit of the society, as well as for the for the other developments. Likewise, the same is the situation when we come to the originality. Some ideas must be there. Ideas must be ideas must be there, or something which has already been in the existence. So we come across a question whether we have something different or we can create something different or not. It is the question. Likewise, we read some of the books or the novels. We get some of the ideas that, oh, this is the way to write something. But there can be some different ways of writing something, or something new storytelling, or the types or the methods for telling the something different. These are the things which relates to the originality. Now the question is copyright. Copyright in general is the nothing which is, if I have something in my mind, okay, I have created a something, or I have written something in mind. Likewise, sometimes what happens that if any picture comes in for the release, or if a picture is thereafter someone comes forward with that my storylines are the more or less the same storylines, and this has been infringed by the other party or the producer of the film, it should not be there. So what basically happens is that whoever has the idea in his or her mind, it is not relevant. The relevant part is that we need to put it into the tangible form, or we can say that we need to put in the form expressed it. Unless and until the ideas are not expressed or kept into my mind, then it cannot be said that ideas cannot be protected. It means that who comes first will serve the first. These are the things. Now, basically, when we go through the part of, that is called the how the ideas or how the things are protected in copyright, trademarks or patent acts. In general, I am making the submissions or the geographical indications or the design acts. What happens that some categorizations are there. Categorizations means that we put certain category or the class under which certain rights are protected or some sort of protections are being given. Likewise, if we say that we talk about the Trademark Act, then what happens if we file the application? Then there are several classes under which the applications are filed. The applications are generally filed for what? The applications are filed for the services as well as for the goods. Similar is the position of the patent. When we file the applications, patent applications, then it must be filed under some sort of different categories. Different categories means that there's like where conventional engineerings are there, mechanical engineering and other engineerings are there, agrochemicals fields are there. So these are the classifications wherein we need to file the applications. Now we come to the question of copyright. Copyright, definitely copyright can be filed, any application for the copyright can be filed in different classes or categories. So we need to define what is the copyright and how the copyright different classes are the copyright. The basic thing is the first thing is the adaptation. The most important part of the copyright is the adaptation. Adaptation is literally, or in a common parlance, we can say that it is some sort of conversion from one part to the another part. Now the question is, what can be converted or not converted? Likewise, some dramatic work. Then dramatic work can be converted into non-dramatic work. Some literary works or some artistic work that can be converted into the dramatic work. These are the process by which the things are converted from one form to other form. Now musical work is also there, that is the rearrangement or arrangement. And some of the things which are there, like when we talk about the something which is artistic work, if we categorize something, what is the artistic work? Artistic work is something which is represented in some form. It is very important to understand that what is represented. It can be some sort of diagram, it can be some sort of paintings or sculpture, whatever that is. But it cannot be necessary that the work which is the artistic work should be have some artistic values. That can it may be the position that I represent something, or if I create something which falls under the category of the artistic work, but it does not contain so much artistic values. So to have the artistic work and to contain the artistic value, these are two different things. There cannot be the situation that both the things can be the same. Now come to the point which is called the author. Author can be the person who generally creates the work, be it in the form of literary works, be it the musical part, be it cinematographic part, or the other parts are there. So now there are different ways to protect the right or to gain something, some monetary benefits, or to completely project the things in the market. Different methodologies are there, different technologies are there, and as well as the techniques there. But as a lawyer or as a common person or even as a law student, what we need to understand is not only what are the laws, rather than what are their implementations and how they are implemented. Likewise, if I am giving you an example of a agreement, what happens that when we go through, you might have, or you might, you have been regularly visiting or seeing the promos of some of the advertisement promos or etc. on the television or the other modes. Generally, what happens to promotional activities? If I talk about the promotional activities, so that promotional activities itself is not a very small thing. It needs a lot of efforts to produce it, as well as to protect it, and as well as to convey the message to the public viewers. When we go through the any of the news article or any of the promotional events or any of the advertisements, several parts, several entities or are the which are the integral parts of those advertisements are there. They are responsible for making that advertisement or the creation, whatever it is, in the literary form or even in the cinematographic films. What are important things? The first thing is that if we make the promotion of anything, let us take the example of that we are promoting some show, then there must be some brand ambassador, or we engage someone to promote our product just because he or she has the face value. So we just want to put our product in the knowledge of the person, because general persons are influenced by the, I mean to say that by those promotional activities or those advertisements. So if we go by the advertisement agreements or if we go through the promotional activities, what happens is that we need to first go through the endorsement agreement. The endorsement agreement generally what talks about? The endorsement agreement talks about the terms and conditions on which the person or the actor, I would say actor, agrees to endorse the product. For the endorsement, there are some script that the person has to say these lines on dot lines. That there is the visual recording, sound recording, background music if required. There are the background music for it, and the other things are also there. Now, once if a person or if a producer, who is the producer? The producer is the person or an entity who is responsible or who is solely responsible for the creation of all those rights or all those pictures or other things. The producers may be the owner, the producers may be the publisher. Sometimes different persons are different entities are different things. So now what happens if a company approaches any person for the endorsement of the product? Then the question comes into the picture, how the agreements or the things are drafted so as to protect all the things together. The first thing is that in a good way, the product should be promotional, should be, promoted. The second one is the persons who have created all those the rights or who have created all those ideas and expressed all those ideas, they must get the due credits. The third one, the actor or someone who is promoting the purpose, he or she must get the compensation or must get the benefits of it. But at the same time, what happens that we also need to look into the other aspects. Likewise, these are not only the laws which are confined or related to the IPR. Some other laws are also related or interlinked with these laws. Broadcasting rights there, telecasting rights there, all these laws. If some contents are being viewing airlining there, then what happens generally? We need to look into the whether are these lines or the contents of those advertisements are not against the law, or we consider it against the public law or the other things which are derogatory in nature. These things are very important while we go through or while we draft some of the agreements which we usually go through. These are the practical aspects, because initially I have also said that I will talk about the practical aspects of all those things, because the laws are there and you all are aware about all those things. I am sure about it. So these things are there. While drafting the agreements, what happens, or in general terms, I'm saying that when the agreements are there, we need to look into the terms. What terms are there? Sometimes what happens that if we engage someone, there can be the chances that the engagement is only with that person, or the engagement can be with that person or the other persons associated with the persons. In both the cases, what happens that we need to draft the agreements, different wise agreements, if in person to person or as a whole, the agreements are there. The agreements, generally endorsement or the other things are there, time duration is always there. The contents, what the contents needs to be done, there are the slot, at what slot the agreements should be aired or should be viewed by the, because the channels where once they put it into the air, they usually fix the time for it. Like the prime time is there when the more viewers are likely to join or more viewers are likely to see those the advertisement. These are the points are there. Now, the question is, when we talk about the other aspects, likewise, you must have gone through the wrappers which are there for wrapping the products. What happens that there can be the cases that the products or the material, the contents which are written over the wrapping, they can be protected under the copyright. But there are the chances, the basic ingredients are there, that there must be some skill or something new or something different which can be there. Then only that can be protected or that can be registration. Why the registration? Sometimes the question is, if something registration is not compulsory, but it gives the primary evidence that I have the registration, I hold the sole authority. Once a person who gets the copyright over his article or over his literary work or what form of the works are there, then he has the exclusive right. Right for what? He has the exclusive right to use it for himself or herself. He has the right to transfer some of the rights. Either the exclusively he can transfer the rights, or some of the rights can be transferred on license basis, which we can say that license basis. Now let me allow to give an example for making this more clear. Likewise, what happens when a film is produced? Before the production, then generally a production house is there to produce the film, who is responsible for each and everything, be it the director, be it all the things are under him. I mean, he is the one person who creates, who is the responsible. In the layman terms, I can say that who is the person who is responsible for it. Now, what happens that when I am talking in sense, because broadcasting term is also there. So what happens that when a film is produced, then film is produced, different rights are there. Different rights as well as due credits are needed to be given to the persons, the authors who has created those rights, because it is not a single right. It is a bundle of rights which are created there in cinematographic films. If I am talking about the or videos, something which is produced, bundle of rights is likewise their choreography is there, music scores are there, music background sounds are there, lyrics are there, each and everything are there. So story, the way the stories are narrated, all the things are there. So now when it comes to the, I mean, to communicate to the public, there are several modes through which the communication can be done. Earlier, there were the modes which were used like a cinema hall, the old theaters or the cinema halls which were there. But right now, there are several modes that can be through the multiplexes or single theater is there. Even through the wireless modes are also there. So in that case, what happens that we need to define those rights, or to those areas where the rights can be assigned, or license can be given. Whether the license can be given or that some rights or some sort of rights are assigned, right? Rights are assigned because it gives the right to reproduce it or to make it public, we can say. So what happens that usually we see the movies, we do not try to understand the things which are involved in it. Likewise, there are the rights. Some rights are there, likewise the right which is called airborne right, terrestrial right. Airborne right is something which is given on the, some aircrafts company where the films are viewed. Terrestrial rights is there. Terrestrial rights is there only not only for the rights, a specific territory is there. The rights can be given for the exhibition of the movie for any specific territory, or it can be given for the general territory. As a sometimes what happens that it is given as a whole territory, or sometimes it is given northwise territories, or even specifically some sectors, zones of the north area or the other zones. These are the ways where the person can, the ways, the mode by which assignments as well as the license are given to exploit the things, and to by assigning those rights, the person who assigns the rights, they get the royalty. Now, what happens that sometimes when the rights are given, there can be the chances that rights are given on the exclusive basis or limited basis. When the person, if some rights are given there, then he or she can have if the exclusive right, then he has the authority to decide all those things, whether the rights are there, how to use or exploit those rights. I will not go into very detail on all these things because these things are always there in the law. Now, what happens that when we go for registration of the copyright, as I have already said that copyright registration is necessary. It gives the prima facie evidence about the author, about the ownership of those rights. There are generally rights, if we file for the copyright applications, the way the same can be filed for the literary works, musical works, sound recording, cinematographic films. These are the things. So what happens that when we go for the registration of all these rights, then I am just going to some of the normal procedure, what we need to do. There's a very basic thing that we need to file the application, as well as we need to give the statement of particulars. A statement of particulars is given, which broadly defines the terms. It defines who are the author, who is the owner, whether the publication is there or not. If the publication is there, like literary work, if it is published, then the details of the date of publication. Thereafter, if subsequent publications are there, then subsequent publications, details of the subsequent publications are also required to be given. These are some of the basic things are there. We need to give the power of attorney if it is filed through some of the authorized agents or the advocates. But at the same time, all this statement of particulars as well as a statement of further particulars, these two things are there. In a cinematographic work and sound recordings, statement of further particulars are not there. Because if we file the application for the statement of further particulars are required in the case of some of the adaptations work are there, then the details are required to be given in that form. Now, what happens when we file the application for the registration? We need to take the NOCs or the assignment agreement, through which the assignment is given in the favor of the person who is the applicant. He can be the owner or he can be the author it all depends upon, it varies from person to person or the situations or the legal relations between the parties. So what happens, we need to, if we file for a cinematographic film or any other work, we need to take the permissions, NOCs from each and every individuals, because they all have some of the valuable rights. The rights are created separately, the rights are created by them. So we need to take the permissions from them to make them aware that we are going to file this one. As the assignment agreement is there, we need the original copy or the processes are there for filing, the copies are there. So we need to take the permissions or NOCs before filing the applications. When we file all these applications, these are the procedural part for the filing part are there. When we file the application for the registration, what happens is that it is put under the category of a formality check. Formality check, we generally, in a common man language, you can say that it is for scrutiny purpose only. And if there is any discrepancies in the scrutiny part, if any discrepancy is found in the scrutiny, then due intimation is given. The process is, the due intimation is given just to rectify all those discrepancies. Thereafter, the time period, the minimum time period 30 days is there. If formality check is passed, then 30 minutes is there, 30 days is there to get it checked. If some oppositions are required to be given, then if someone opposes, then that will be decided. Otherwise, first come, first serve basis, it is decided. But it all depends upon the time duration. It all depends upon the time workload of the offices, due to which how long it would take to get it registered or to issue the registration certificate. The registration certificate, once again, I am repeating it, the registration certificate is entirely, or we can say that is a prima facie evidence. We need to establish that I have the right over these things. So once again, the question comes with the same thing, that unless and until any of the ideas is not reproduced in any form, then that cannot be registered, or then that you cannot get it protected from the other persons by misusing it or infringing it. These are some things about the procedural manuals. Now I come to the point that is some sort of rights. Likewise, the broadcasting rights. Broadcasting rights, there, that is called the broadcasting reproduction rights. Once something is broadcasted, then that right can be given to some other persons for broadcasting reproduction. It is given for 20 years for broadcasting reproduction. And in that case, if some right is given to some other person and some other entity or person produces or uses it in some other way for his or her commercial benefits or for other purposes, without the permission of the owner, then that is against the law. That cannot be permitted. Performance right is also there. Someone has the right to perform something. Likewise, if we say that dramatic work, we usually say dramatic work to make it more understandable. What is dramatic work? Something which is already written, and I have to perform. The concept, the visualize, I will visualize it in my mind. How do I perform it? Then I will perform it according to my own wisdom, according to my own thoughts or the skills. Then I can perform it. The performance right is also there. Even some of the rights, sometimes what happens that the rights are assigned or licensed to some person, right, assigned to some persons. Then what happens, some residuary rights are always there with the author. The residuary rights are in the form of to protect something if there is some sort of distortion, if the contents of those things are not as it is as in the original form. The royalty form is or the compensation and damages are also there, which can be claimed. Now I come to the question that is computer programs. Computer programs they are also registrable under the Copyright Act. Computer programs also includes the computer database, which are excluded from the category of patent. So once we create the database, I'm just giving you an example of a database. Likewise, if you go through the IPR site, the government site, patent office site, you will get the ideas how the database are created for each and everything. Likewise, the database are given for the copyrights, for the trademarks, for the patent marks. And the database are created in such a way that if you put something for search, the search engine will accordingly search. The database are created in that form that your search or accurate search or to that extent search will be made. Likewise, if let us take the example of patent case. When we go through the database of patent, what happens that we generally look into the form, some compiled database are there. Either we go through the company name, then we get the database of all the patents filed by the company name. It is also a skilled or a labor, not only the skill but the expertise to make all those or compile those things there in the data. The things which are also there, like some categorization are there. If something which is patented, or if patent grant there, if the patent is granted, then that category is there. If something which is in pipeline, that category is also there. So these are the ways, these are the method or methodology for a creation of something new or something reusable. Now something comes with the like the structural. You usually go through the buildings and you see the, yes, this building is a quite good one. So but while constructing the building, not only the construction work is there, the method or process is there to construct the building, rather it also puts into the efforts of preparing design work or preparing layout plans. Are the compilation of all those things which can be protected under the copyright laws. You might have a few days ago, a news was circulating about the mobile hospital. The government has just either started or initiating to start some of the mobile hospital schemes, wherein different big chambers are to be put on a container basis. In that case, what happens? Likewise, if we take the example of that mobile hospital, that a container based hospital, what happens that different chambers are there and different chambers are created or fixed or something arrangement or rearrangement are there to create the whole things. There may be the chances that all the arrangements are done in a specific way or a specific manner wherein patent can be granted or patent cannot be granted. Simply if some sort of arrangement or rearrangement is there, then the patent cannot be granted. But there can be the chances the design overlook how the things are, how the plans are been done, how different chambers are created, the layout plans are what are the layout plans, how to use the areas, the specific areas. These are the ideas. So that can be protected under the Copyright Act. Now I would like to give you some of the ideas about some rights, how the rights are protected. Basically what happens that we have the laws to protect the rights. If someone infringes, the infringement is there. In a common man or common parlance, we can say that what is the infringement? Infringement is which is unauthorized use of anything. Unauthorized in the form of if we like was literary work, suppose if I write something, if I quote something from some of the books, and if I do not give the due credit to the author, then it will come under the purview of the infringement. How the due credits are given? You have the habit of, or you, the faculty must have been teaching you about writing the references. What are the needs for writing all those references? Because whatever we have write or whatever ideas we have taken, if we quote something from somewhere, then we need to give the proper due credit to that person. The ideas are there to give the credit for that person's production, reproduction, or the uses, or you can say that the exploitation of all these things are there. That can be in the form of legally form, by way of assignment, or the other things are there, or by way of illegal terms. When the things are illegally done, then court has the right to protect the rights of the owners. There are certain mechanisms to protect all those rights. Likewise, the first right which is there, we can go for the civil remedies, we can go for the criminal actions against those persons, where the things are seized, search and seized. The procedural or different procedures are there to search and seize. What happens when we go for some sort of civil remedies? We generally come to know about that certain pirated goods are there, or infringed goods are there, which are stored in some place, or some person is dealing with all those things. It is not only related with the copyright. A similar modus operandi is similar in the case of the trademark act also. So what happens? We generally go for that places. Even if we go for that places, we need some sort of protection or some sort of order from the court. Civil remedies, when we talk about the civil remedies, what we do, we get injunction order from that person, against that person from the court, as well as we seek damage and other appropriate reliefs. Why do we need the damages? Because we have put our efforts and the skills in producing all those things. Once we have produced it by our own skills and labors, unless and until I do not permit someone else to reproduce it, the reproduction or illegal use are prohibited by laws. When civil remedies are taken, while filing the question arises, okay, I have to initiate some actions against the person, seeking some sort of injunctions as well as seeking some damages therein. What should be the proper recourses to do all those things? While filing all those things, basically what happens that it is a very general practice that we need to go through all those things, like where the place the infringement is done, or where I can file. These things are there. Place of jurisdictions is always there, where the suit can be filed, as well as the place it can be. I mean, court-wise, if we take the court-wise, then it all depends upon the claims which we made. If the claims are to certain category, if we made the claim up to that level, then it should go to the high courts, or otherwise to the district courts. It all depends upon the damages we seek from that, apart from the mandatory reliefs we claim for. And in that case, what happens? The seizure process is there for seizing any unauthorized or illegal goods. The LCs are there to seize all those things. Now, we can also go for the criminal proceedings, where generally what happens that the application is given to the persons who are to the SHO or to the concerned person in the officer in charge in the Thana, and that there the process can be initiated. There is some other things. Likewise, if we go something which is a duplicate or which is a pirated one, I am the owner of those things. if I come to know that the things are imported in India. There can be the situation that the things, either the things are within the country or imported in India. Then in that case, what would be the situation, or how can I protect my rights? In that scenario, what happens that a person, unless and until something is imported in India, then it must go through the checkpoint, that is the custom check. Then we need to go to report to the custom officer or the commissioner or the other concerned person. We need to give a written application with the evidence. What sort of evidence are required to be given? The evidences are required to be given that I am the owner. Prima facie evidence are there with me that I am the owner and I have originally created all those things. And I have the right to get it protected from the other person, be it in the form of reproducing it or be it in the form of illegal use of it. Then in that case, what happens that the person, that the goods were seized generally, but before seizing, the proper due care is taken. The opportunity of being heard is also given, because it is the principle of natural justice that opportunity are given. Opportunity are given to the other person to defend the case. Then if the things are found right, then the goods are seized, and then we need to take the some order from the court to get it demolished or to get the possession of all those things. These are the things basically. Now what happens, sometimes someone issues or some, if suppose I am something which I am reproducing or which I am which I am making in circulation to the general public, and someone issues a notice or someone communicates to me with different modes, threatens to take legal actions against them, irrespective of the fact, if he or she is not the owner of that copyright material, then what happens? How can I protect myself if I know, genuinely I know that this one is not the protected copyright, or if I am the author of this right? Then there can be the procedure which can be used for getting the declaration, for getting the order of declaration against those persons. Yes, what is declaration? Declaration is I am entitled for this one. It is some sort of recognition which we get from the court, that I am, the court declares that yes, you have the power, or you are the legal entity or the person who have the rights, all the legal rights over the properties. So these are the basic things which I needed to discuss with you, which are more related with the law, as well as some of my experiences which I have come across. Likewise, I have dealt with some agreements with you. All those agreements which it is a not a in a practice, or it is a ethically not right, legally not right to reveal the name of the clients, but still the things which I have gone through all those agreements. So while drafting those agreements or while vetting those agreements, these things are always kept in mind. Broadly knowledge, the things is that copyright, if I have an idea of the copyright or what are the rights or how the rights are protected, all those things are related with each other and interlinked. We cannot read the copyright or any of the other IPRs branches in isolation. We need to read all those things in totality with all the rights, with all the other laws. So I hope I would make you understandable for some of my basic experiences with you.
Okay, sir. Yes, my voice is audible, sir.
Yes, sir, your voice is audible.
Okay, sir. Very nice the presentation you have given. You have tried to summarize the huge topic copyright into some of the minutes. This podium is open for the student. If any student or faculty having doubt, so they can ask about the concept of copyright.
Sir, I have a small request for you. Earlier, I have also
Yes.
intimated that I have some other pre-engagement with some of clients. I might have to go to that place, some other person. So for that session, if you excuse me, I would be very happy to for it. Or
Okay.
we can do one thing, that if it is required, we can arrange it for some other days. If
Okay, no problem, sir. So, on the behalf of the ISC IMT College of Law, I propose a vote of thanks to the faculty and the students for the patience listener, and thanks to our learned speaker, Advocate Rupesh Kumar Sinha ji, and thanks to all the persons, and thanks to all. Thank you very much.
thank you very much. Thank you, sir. Thank you, everybody.